Good afternoon, everybody. Today is Friday, June 26th. We've got noon Eastern. Thank you for joining us for our monthly One Voice Public Policy webinar brought to you by the National Tooling and Machining Association and Precision Metal Forming Association. My name is Omar Nashashibi, founder with Inside Beltway, one of your lobbyists here in Washington, D.C. I'm on my own this week, or today rather, as our colleagues are traveling this afternoon from the Policy Resolution Group. So we are going to run through quickly, as usual, a number of items to cover, ranging from Capitol Hill, where we have seen some momentum on several pieces of legislation recently, into the significant amount of regulatory action that actually happened in the last several weeks, and some more that we are expecting here in the coming months as the EPA gets ramped up. And of course, no shortage of things to talk about on tariffs or so. We'll try to get wrapped up here a little bit after the 12:30 mark and try not to keep folks too late. And again, all of these are made available along with the recordings. As in the past, please do type in any questions you have into the Q&A box, and please be on the lookout when we get a few slides into our regulatory space, and we'll be asking for some of you all to fill out a survey related to metalworking fluids and some actions that the EPA is considering taking here in Washington, D.C. But as always, let's start up on the top. Let's start up on Capitol Hill, where both sessions of Congress were in for most of this week, and we're able to make some progress, at least from the Republican perspective, on some of their priorities. The Republicans were able to pass what we call Reconciliation 2.0. The second reconciliation bill was signed into law by the president on June the 10th, with, as expected, only Republican votes. The reconciliation process is used in order to escape having to get to 60 votes in the United States Senate. It allows the chamber to only move legislation through 50 votes, which ends up being partisan. Democrats did it for Obamacare. Republicans have done it twice for taxes. Biden did it on one of his priorities as well, or a couple. And that's where we look at this reconciliation process being so important in the U.S. Senate as a way to clear those log jams. On the second reconciliation bill, however, it was very limited in scope and focused on $70 billion for immigration enforcement related to ICE and Customs and Border Protection. The funds are outside of the normal FY 2026 through 29 process, and that's why this is so significant for manufacturing. Not the immigration enforcement funding itself, rather, but the funds now are no longer going to be on the table as a bargaining chip that might lead to a potential government shutdown, whether it's this October or in future Octobers after the September 30th fiscal year ends. And that was a strategic maneuver here. It's through the rest of the Trump administration that, at least related to funding Homeland Security's priorities for ICE and CBP, they would not have to deal with those again. However, that does bring us to leaving many other topics that were not addressed in this legislation that the president signed. Does not include tax or trade policy, defense spending. Many of those are being considered to go into Reconciliation 3.0. There's a number of skeptics on Capitol Hill and on K Street at whether or not they're going to be able to complete this legislation here by July deadline that they've set for themselves. The House, as of now, is slated to depart Washington, I believe, on July 24th, that Thursday or so, and they will not return until around Labor Day. And similar is the case, the Senate was sticking around for a week after, so there's not much time for them to get through Reconciliation 3.0. The Speaker has been hosting weekly meetings, at least weekly, on this now for about a month, and they're discussing what might go in there. However, when you discuss waste, fraud, and abuse, that typically translates into certain cuts for programs that are out there, particularly related to SocialNet, and that might cause some challenges for moderate Republicans that are there. The president, of course, wants the Save America Act. That's a voting bill on which he's been focusing to be included, which would increase the bar and the threshold for getting that in there. It makes it even more complicated. But of course, the war funding for Iran and Pentagon replenishment, that seems to be the greater topic that they want to take a look at. Now, the White House has indicated they want $350 billion. They want it included in this Reconciliation 3.0. That seems unlikely. The Senate appropriators do not feel that they want to include this kind of spending on a reconciliation bill that would skirt their process. And in addition, we just received the supplemental on Wednesday afternoon from the White House with just an initial $80 billion that's in there. For those of you that are in the defense space, that's important to look at. I think somewhere around 20 billion was for munitions, and then they had a mix of other areas. I think out of the 80 they sent up, 67 billion was related to the Pentagon. The Pentagon has told the Congress they're going to run out of funds for the Iran operations and related sometime in August. And that's what makes this timeline to complete everything that the president and certain Republicans want on the conservative side more complicated. We do expect a legislative agenda for the rest of the year to take shape over the coming month. What they do and do not complete in this Reconciliation 3.0 will dictate, and how far they get on appropriations this summer will dictate how far we get in the year end on some of those what we call lame duck sessions. Of note, the House has only passed one of their 12 appropriations bills. That's in addition to much other work that remains to be completed on highway transportation, National Defense Authorization Act, water resources. So we've got a ways to go on some of these items. Onto regulations and a few of those issues that we focus on there as well. Just want to flag for those that are on the HR side, there's not slated to be a Department of Labor penalties increase for the 2026 year, and that has been changed for the Civil Penalties Inflation Adjustment Act. The 2026 adjustment has canceled entirely effective May 27th. This is posted, that's out there. We'll see if that is subject to a legal challenge on that. This is for you all that might be working with legal counsel or others that are focused in this space within the HR department. Encourage you to take a look at some of these recent opinion letters that have come out from the Department of Labor. WHD stands for Wage and Hour Division. We've put in here under the FILSA, Fair Labor Standards Act, what we've got a few areas here, whether an employee exempt pursuant to FILSA can perform additional work in a secondary role at an hourly rate, and if so, what overtime implications may arise, speaking to whether salaried employees are taking secondary hourly jobs, may keep the exemptions, but overtime can still apply. So making sure you take a look at that as well. There's a straight time and overtime earnings and the combination of bonus and how that's tied to satisfying the overtime and bonus pay requirements. Make sure if that's of an area of concern to note that change there. And this always comes up in a number of discussions across the HR space, whether time spent during a meal break voluntarily traversing an employer's premises and passing through a controlled access entry and exit is compensable under FILSA when the employer allots employees a 30-minute meal period during which they are allowed to remain on the premises. It's similar to donning and doffing some of the PPE that's been discussed there as well. So talking about it not being compensable time though on these meal breaks is a little variance. So again, watch these spaces closely. Always again, not giving legal advice, but just more for education information purposes. In honor of Paul there. Department of Labor comments is seeking comment rather on hearing loss evaluations. This is not necessarily targeting manufacturers exclusively. Obviously, as you can see, it's got audiologists and other medical professionals. It does include input from employers as well, but we did want to flag this particularly in that it could be an indication of a future regulation to come on the monitoring that is used and the testing methods that are put in place, and knowing that in some of our operations and some of the stampers in particular, that this might be an area of focus and concern. So what we always say, once it's on a radar screen, it tends to be difficult to get it off, but take a look and pay attention to this as we follow. We'll keep you updated as well. For some of the members that have focused on the Trump accounts, these are the ones where a retirement account could be put in for a child up to 18. They wanted to put a clarification here that under the ERISA, there's a technical release that came out from the Employee Benefits Security Administration, Department of Labor, saying that these Trump accounts will generally not be subject to Title I of ERISA due to their unique status as an individual retirement account that may be funded by contributions from employers, governments, charitable organizations, and family members. So as those develop, as we can imagine, there'll be more tweaks and clarifications with that novel concept that's being rolled out there. Onto the EPA side here, a few things to note on the community right to know. That's what EPRA is. It's the Emergency Planning and Community Right to Know Act, hazardous chemical inventory reporting. Whether you know it or not, virtually every one of you on this call has either a Form R or a Form F that, depending on what you've got on your site, that somebody is filing with the department or with the Environmental Protection Agency to notify the local community that a certain amount of types of chemicals, solvents, degreasers are on your work site. And they are making some, not necessarily new, they're not new reporting obligations, but they are doing alignments between EPA and OSHA to make sure some of those reporting requirements are there. And there's going to be some new reporting categories. If you are subject to this, somebody at EHS should be familiar with it, and that will something you want to just pass along to them on that community right to know issues. Proposed NEPA reforms under the National Environmental Protection Act. There's a number of policy act rather. There's a number of things that they're looking at on compliance and how to streamline some of the reporting here under this that we've been expecting for some time on simplifying some of the categorical exclusions, sharpening the focus here, and then putting on this one's the important one, reasonable page limits on environmental impact statements that can run 661 pages. And so the EPA has already proposed a rule previously that would cap those at 150 pages, just as that part of that is just delay and slow these approval from a permitting standpoint. And what we are also looking at are a few other things, just notifications here. EPA is rolling back some emissions limits for the U.S. Steel, as in the company, United States Steel Corporation's plant of taconite in Keewatin, Minnesota. That's based on a finding from them, from the Trump folks, that the federal implementation plan set in feasible emission limits under the Biden rule there as well. Similarly, EPA is withdrawing the affirmative defense rule. And for why this matters for those of you that have engaged in an area such as this, the withdrawal reinstates a framework that distinguishes between liability for noncompliance and situations where noncompliance occurs as a result of circumstances beyond a facility's control and in their mind, so that way they're not punishing good faith operators for emissions caused by sudden unavoidable events. So flag that if it impacts you, you likely are aware of that as well. EPA in the Cuyahoga County area, folks, there's a redesignation and now put you into ozone attainment. This matters going back to the permitting and paperwork issues as it relates to how they deal with some of the permitting approval processes locally, depending on how many emissions and the violations there for that local emissions requirements. So it's a bit limited, but it is kind of a trend that we're seeing. This is not necessarily limited to California. Think of it this way. All of you states that are in places where your government is following the California emission standards on vehicles and other areas, the EPA is what they're doing is under California, they've got the Clean Air Act waivers they've had now for 3 decades. And the department, the EPA is going to send them these waivers up to Congress as a rule, which they haven't done. They've just been waivers, been granted under the law. But their concept is to turn these waivers into actually rules that they can send to Congress for review, because Congress can use the Congressional Review Act so long as a rule has been put out within the past 60 legislative days. Well, now if they turn these waivers into proposed rulemakings, then Congress can take a vote and say you cannot do these again in substantially similar format. That'll oppose vehicle emissions and some other areas that they're looking at doing there. This brings us over to the action item, if you could, before we wrap up on the regulatory and we pivot. You'll notice coming up here shortly in the chat for everyone, we're going to put a link for filling out a survey, which you'll see on a link as well to the next slide. Yes, this date is accurate. It's not an old slide. This is from March 2024, but we bring it up because the EPA is working on a draft risk assessment for a certain chemical that is being used in a number of machining operations that we understand. The big question that the EPA is putting forward is, in fact, an assumption. As you see down here at the bottom of the slide, the EPA is making an assumption that 0% of removal is occurring during treatment. They're alleging that the use of this solvent here, of this item, is being released potentially into wastewater for general treatment facility and is not coming in to proper recycling by third party or others. We've been out. The Fluids Association, ILMA, has reached out. Independent Lubricant Manufacturers Association has reached out to us and others asking for information to help with the industry's response to the EPA, whether or not this is simply being recycled through a third party, whether it's going to a direct discharge, or it's just going down into, so to speak, the drain. If you all could please fill out this anonymous survey, we're trying to get it done by mid next week. We're going to anonymize it, as I said, we'll get the information over to the association that's going to take the lead on this issue. And if it's not of interest, then also please let us know. But in reaching out to a few, it has come up as an area of concern for a number of our manufacturers that are out there. As we take a look at the next steps here on tariffs and jump into that, so appreciate any of you filling that out there. On IEEPA, we'll start with the tariff refunds, the legal challenges, before we get into the Section 301s, the 232s, and next steps on what to expect on USMCA. On the IEEPA tariff refunds, this is accurate, I believe, as the 10th of June, whatever that Tuesday was. They gave an update to the CBP. The CBP did, rather, to the courts. How to read this slide is that you've got 53 million entries. That means articles that entered into the United States under the IEEPA. These are the tariffs that the Supreme Court ruled illegal. Out of those 53 entries that are eligible for a refund, they cleared 8.3 million, with 15 basically moving through that process as well. So they got the refunds out for 8.3 million. We've spoken to companies that have gotten a significant portion of their refunds back as well. What we are seeing is, from a number of areas, the things that tend to slow it down are going to be those where you don't have all your ACE, your portal system set up, you don't have an ACH set up, but they're going through this. 330,000 are the total that are eligible on there. What they did is they made adjustments earlier this month where they've now created 3 different portals, well, I guess 4 different phases potentially, but 3 as of now. Phase 1 is the one that's currently open. We just showed you that slide. If you are an importer of record and you brought in a product directly, then you must go into this portal that Customs run and file for a request for a refund through what we call the CAPE program. Work on that, get through that process sooner rather than later. If you're not an importer of record, there was a lawsuit, and that is trying to give standing to those that aren't importers of record that buy through a supplier. That still seems like a long shot, and your best bet is still working through the supplier or the entity to which you paid that tariff. Phase 2 is going to open up on Monday, June 29th. That's what we call reconciliation entries. They are imports that have anti-dumping, countervailing duties, anything more complicated on there that has to be dealt with. Then they now have shifted these final liquidated entries, ones where Treasury's already got the money. It's no longer sitting in a deposit, and now you're going to have to end up paying and dealing with this phase 3 process that's going to take even longer and not start likely until the end of July. IEEPA Phase 2 refund portal, as we mentioned, opens June 29th. So if you have a 232 or a ADCVD that's on there, that's how you'll get a better sense of the timeline for when you might be able to apply for that refund status. That's coming up again on Monday. On to the tariffs that are going to be replacing the Section 122s that are out there. We mentioned those briefly. They continue to go through court challenges. They do remain in effect, though, so we don't expect any near-term changes. As of right now, it does not appear you're going to get a nationwide injunction on those Section 122 tariffs prior to their expiration on July 24th. So that seems to be marching forward, and as is this administration on 301 tariffs. Let's start on those 301 tariffs. They are ones that have been challenged in the past. So quickly, the Supreme Court, as recently as 11 days ago, on June the 15th, declined to hear the challenge to the Section 301 tariffs that have been put forward. Why is that decline important? That is yet another time that courts have declined to even hear cases challenging the Section 301. And now that the Supreme Court has done so, that makes it even less likely that future legal challenges might succeed to the replacements for the IEPAs. We've had the Court of International Trade and the Federal Circuit has previously upheld these. The Supreme Court action leaves those rulings intact, and it likely strengthens the legal foundation for this administration moving forward, which has really done a, a meticulous job of going through the process of imposing these 301 tariffs. They are making sure they go through public hearings, public comments, a second round of public hearings, second round of public comments before they ultimately put these tariffs in place. And they're on time to potentially put the tariffs in place by July 24th, when the tariffs of Section 122 are set to expire at 1:22 a.m. These Section 301 tariffs, they are focused on forced labor. There's multiple 301s that are pending. These are the ones that are looking at forced labor. What U.S. Trade Representative is claiming is for that the of the 60 economies that they're targeting, and on the next two slides we'll give you actual names of where these will apply once and if they take place, that you've got a group of 46 countries that don't have a forced labor tariff that's imposed. And so we look at how these 46 economies, rather, or countries that are in here and how that impacts. We've got two different rates. We've got 10% and a 12.5%. The economies that have a partial regime addressing forced labor or have already committed to impose and enforce such prohibition on forced labor as part of the reciprocal trade that they did last summer with the Trump administration, they're at 10%. The others are at 12.5%. So here's the 12.5%. For example, it's going to be at a lot of countries that might be familiar. There's China on here, Japan's on here, India as well appears. You have a few others where we might have some members involved, Vietnam. And so if you're importing from them, Switzerland, South Korea, if you're shipping products from them, or if you are competing with them, then these countries are facing a 12.5% tariff. The others that are at 10% tariff, those will come in, such as Canada's on that list. You've got Mexico, I believe, is on that list. China's on that list. The European Union also appears there. Japan is on this list, however, so you have to take a look at where is your import coming from. Is it on the proposed 10% or the 12.5%? We can only speculate when these tariffs may take effect. As of right now, the informed speculation tends to be they will go into effect on July 24th at 12:01 a.m., as that is the time that they are scheduled to follow up on the expiration of the 122 tariffs. There's nothing in law that says they're going into effect right when the 122s do, but the timing seems to imply that they will. We showed you they've got public hearings coming up, public comment periods all on July the 6th or so, and that puts the timeline pretty well in line for them to get this done by the end of July to move forward with that. So those are the forced labor Section 301 tariffs. The other aspect of the 301 that they're working on is the one on manufacturing excess capacity. This is where the U.S. Trade Representative is alleging that countries overseas are building out excess manufacturing capacity in an effort to take market share away from the U.S. globally and to import in the United States to injure U.S. businesses. That Section 301 is an investigation. We don't have a report on it yet. We do not have a suggested recommended tariff rates on those as of right now. We've been in meetings with the U.S. Trade Representative as recently as this week. Some are indicating we should see that anytime soon. Others think we might not till August. Regardless, within the next couple of months, if not sooner, we might see notification on the Section 301 tariffs that target 42 countries, 16 economies, and this again in this separate action includes the EU, India, China, South Korea, Mexico, Taiwan, Japan. Specifically, USTR is investigating machine tools, machinery, autos, steel, a number of other spaces that impact a lot of our members that are out there. Just to put it in perspective, those are just the ones that we're highlighting there. There's others that they're working on right now. This other on top here is the Board of Trade. The White House, the president, has negotiated with Beijing to create a Board of Trade mechanism that's going to allow companies to request exemptions from the China tariffs. You can go into this access public comment and you'll see where it is, submit a public comment if you'd like. It will be public, and you can request that the government lift, reduce, suspend tariffs on an import coming in from China through this Board of Trade. Companies will have the opportunity to oppose you, but this is the first time that we have seen the United States in a number of years put forward an opportunity for companies to request an exclusion from paying the tariffs, but it's limited to this 301 action on China at the same time. Down here at the bottom, they are looking and taking formal requests on whether or not to continue some of these older Section 301 tariffs on China. So this is the broad one. Anything goes, any tariff on China, you can apply or oppose. This is the labor rights. You'll see their comment deadlines coming up on July the 6th, and then they have another action. All of this happening in July. It's going to be a very busy month for trade. Last tariffs aspect before we get to USMCA and then some industry data here, wanted to flag on yet another adjustments on the Section 232 steel and aluminum tariffs. We'll talk about the policy changes first and then some of the derivative actions. Two quick policy slides here. Section 232, steel, aluminum, and copper. The content threshold for derivatives is now 85%. That's a reduction from 95%. So to read it two ways here, your derivative threshold, a derivative is any product that's made primarily from steel, aluminum, or copper. Well, that threshold is no longer 95%. For it to be considered a derivative and subject to a tariff, it falls down to 85%. That could go one of two ways. It can be a benefit to you if you're importing a product that might have ended up being less steel content. And it also might be a negative again if you make that product, though most of you are 100% content by weight. So note that this is now a change that's on here, and goes change from entirely subject to the tariff, and now they make it entirely subject to the tariff based on that content that's on here. That is a change effective June the 8th. As part of that same action as well, for USMCA compliant, this will impact a number of our members, particularly automotive and others. Not as much automotive, they've got their own tariff relief there, but some other related products. What they've now changed is effective on June the 8th. This dated June 2nd because that's when the White House proclamation came out. But you subtract the value of the U.S. content for USMCA compliant goods that are coming into the United States under this 232 action. So this language is limited to the Section 232, steel, aluminum, and copper. It is then limited to goods that are compliant with USMCA. And if they are compliant with USMCA, then the tariff does not apply to the US value that's in there, however, and this is part of this one subsection here for the 15% tariff rate, then the Canada and the Mexico value is still subject to that 15%. That's how to read that updated clause from proclamation that came out on June the 2nd. Now, to put these all together on where they are, in addition to making those substantive policy changes, they also were able to make some changes on the different annexes. Annex 1A, 1B, 1C, and then on Annex 3. On these annexes, they've now added a new one called Annex 1C, and they moved some things around. But what really stays the same for you all is going to be Annex 1A, 50%. That's going to be primarily the materials that you all use as inputs in your machining process. 1B, typically read that as derivatives, those goods that are going to be 85% more by weight of steel, aluminum, and imports on Annex 1C. That's the new one. We'll show you examples of those forklifts and non-motorized trucks there as well. And the Annex 3, that's the temporary reduction rate as well, down to 15% from 25%. That can be changed. A reminder that if it's got U.S. content, U.S. steel or aluminum rather, and it goes off, gets machined in a product, maybe same as yours, then it comes back in at a 10%. Here's what this was and what it means for some of you all. Again, this should not be a change for many of you. If you were facing a 50% tariff on your steel, aluminum, or copper, it will likely remain the same. On the 1B, this is what we discuss typically as derivative goods. This also largely stayed intact. They had a few changes here or there, but mostly these are staying at the 25%. Many of your customers will be on this list. Much of your goods, if you are covered by the 232 actions, will be here, there as well. This is the Annex 1C that they changed. It's a 15% rate. This is the new annex to which I was referring. Now, this is for those of you that likely are purchasing rather than making, unless you're making a component. But typically, what you are making, what you're using rather here, these are self-rider. Let me just translate. These are forklifts, ride-ons, motorized trucks, non-motorized hand trucks. Think of them as sometimes they're orange, most times they're yellow. They're the non-motorized ones. You're moving pallets by hand around the shop floor. These are the ones that they're talking about. Trucks fitted with lifting or handling equipments. These are going to be subject to a 15% reduced tariff rate temporarily through December of 2027 before it jumps up to 2020, excuse me, to 25%. And that is in their minds are trying to provide additional relief to manufacturers. A number of other provisions in this section as well, but we just wanted to flag some of those that are of the most interest. The Annex 3, this largely remains the same from back in April, so this should not be much of a change from those that have been with us before on the May webinar. But you can see here, you do still have a 15% temporary rate that will increase to 28% or 25% in 2028 on these products and can be changed. We're still within the 90-day review window of April 2nd for changes, and now we've seen a tweak back in May, and this is a substantive change here in June, so we might see additional after this as well. Lastly, on 232 tariffs, we wanted to flag that the European Union has passed legislation to implement what we call the Turnberry Accord, and that Turnberry agreement rather calls for the U.S. to limit tariffs at 15% on imports coming in from the European Union. The U.S. and EU are in a little different places on how to interpret. The European Union wants to also include steel and aluminum capped at 15% and steel aluminum derivatives. That is not the position of the United States. This is the agreement that was signed last August, I believe, negotiated in July, and allow the U.S. to reduce their all-in most favored nations and all the other tariffs to 15%. But the steel, aluminum, copper remain higher, and that's the sticking point with the Europeans. So they put in a couple of sunset reviews and a phase out, automatic phase out when Trump's gone, but this can be snapped back if they don't make progress on steel and aluminum derivatives by December the 30th. So keep in mind, for those of you that are thinking imports from EU, is there another tension point that's coming? Potentially there is, if the Europeans stick by it and say that by December 31st, they want to see a 15% limit on steel and aluminum derivatives as well. Some general trade policy, and we'll talk USMCA a little bit here at the 30,000 foot level with meetings having just come up. The three parties are going to hold a virtual meeting on next week on July 1st. That's required in statute that they notify one another of their intents, whether to stay into the agreement for another number of years, whether to leave it. 16 years you stay in it, you leave it after 10 and 2036. You can also, USTR believes they can leave immediately with a 60-day notice if they must. And then most likely they can continue negotiations until they get to a more satisfactory place on that. Negotiations seem like they're going to continue. This is not a surprise, at least to anyone at this point. They are going to continue past next Wednesday, July the 1st. They're not going to have an agreement. The U.S. and Canada are not in formal talks to the extent that Mexico and the United States are. Canada and Mexico met on May 28, 29 in Mexico City. They met again June 15 through 17 here in D.C. They're slated to go again in Mexico City the week of July 20th. They've met twice on auto, steel, and aluminum. The U.S. has put forward proposals on those. The U.S. has put forward proposals on economic security, specifically addressing China in the North America supply chain. Our understanding is USTR wants to look at this as a North America supply chain. They are asking OEMs in particular what they can do to rid China from their supply chains, to which many reply is not as simple or realistic as the request might seem on it. The timelines are varied. Won't reveal what we're hearing from USTR, but we'll tell you what we're hearing from the Hill. The Hill staff believe that negotiations are going to go likely into late December, is what two separate Hill offices told us last week on there, which does comport with much of what we're hearing. We do think that you could see, you'll see agreements on certain sectors. as they move forward on a rolling basis, potentially start putting things to bed. But again, this is now still US and Mexico. We don't have Canada at the table. The politics are still not in a good place, and nor are they aligned enough for the US and Canada to just jump right in. There's going to have to be a little bit more at the top that creates an opening for staff to really come together in a more substantive manner from conversations that were happening. It's already public on the automotive, 82% threshold that the US wants to see on North American content, up from 75%, and that would be a change from the current rates that they've got right now, and also on heavy duty and trucks. The US is also saying they want 50% of that content to originate in the United States, which would comport to what we flashed there to you on some of those 232 updates on USMCA compliant goods. So we'll see where negotiations continue to go. We've heard from two different USTR staff in the last 2 weeks, 10 days or so, that they've got positive things to report out of Mexico. Can't say as much the same on where we are on the Canadian side, which should be alarming to many. On customs, there's an executive order that did come out here for those of you that are involved in what we call first sale. Feel free to email me. There's a number of issues going on with that tariff calculation methodology that this customs enforcement executive order may affect as well. They are addressing importers of record, dealing with more stringent requirements on foreign companies. Shouldn't impact you, but they are going to increase enforcement activity here over at CBP with DHS, which in some ways may be a positive as well. In a separate action, if you are an importer of record, please take a look at this notification on the Uyghur Forced Labor Prevention Act and the Countering America's Adversaries Through Sanctions Act. These are both directly related as forced labor enforcement guidance that has now been updated by Customs for you to put out there. And circling back to the European Union, if those of you that have been with us for a while and been listening to these for a while, if you go back to somewhere around September of 2023, we told you some point before 2028 that the Europeans were going to expand their CBAM list to cover more products. Well, here it is. The CBAM is the Carbon Border Adjustment Mechanism that the Europeans are using to replace the ETS. That's the exchange, emissions trading system that they've got there. And the CBAM basically imposes a tariff or a tax based on your carbon footprint on a certain categories of goods that are coming in there, including steel, aluminum, cement, electricity, hydrogen. I'm forgetting the other that's on there, lime's on there. This shows that they're going to expand it. Fasteners, castings, forgings, machinery parts, molds, tooling, automotive components would then require them to file reports with the EU showing what your carbon footprint is. If you don't have some kind of a carbon program here in the United States, they say they've got an exemption from it for the United States. We'll see if that goes through, if they use it as a pressure point against Trump or against future administrations. Here's the HTS codes on our last trade slide before we wrap up here in about 2 minutes. Please feel free to type in any questions that you've got in the Q&A box that are there, but you'll start taking a look as you've got some products in here that certainly apply to a few of the members that we see on the call here. Data points, since Paul's not here, we'll do this one in his honor. We are an island of steel prices compared to the rest of the world. This is not coming from us. This is coming from Bloomberg that uses the same data as we do, Steel Benchmarker, as you can take a look at approaching $1,200 on the U.S. price for steel coming in here compared to what Western Europe is dealing with export price, and normally the China price is hovering somewhere in the low 600s to upper 4s, depends on the product that we're taking a look at. So that's pretty consistent there. Industrial subsidies from the OECD report that came out. You can take a look at the below market borrowing that's out there. Government grants have certainly increased, income tax concessions. It's happening all across the board. On a more positive note, the Small Business Administration has exceeded its 23% target for small business contracting. They were able to hit a 28% rate for fiscal year 25. Back over on the trade side, China's continuing to expand its exports, and on its imports are going up, but as you can see, the exports are continuing to go faster than expected on this jump, despite some of the tariffs, in part after some of the discussions with the administration. On the other side, we're seeing a 34% decline in steel exports to the U.S. That does go parallel with that steel slide as well. We are an island of steel prices when we've got a limited amount of metals coming in here and available. And we did see some better numbers come out, so we could probably update this slide a little bit here. but U.S. manufacturing did slow down here, at least on the non-durable or on the durable goods side rather, in May. So we've got some of those challenges ahead of us, hopefully ahead or behind rather. Staying connected with us, we did record we're recording a One Voice podcast coming up this week. We've got another one that should have just posted late last week. Please stay tuned. We're starting to increase our focus on politics in that as we're creeping through the primary season. As always, feel free to reach out to us anytime and with any questions you've got, anything that was included or not included, feel free to type in any questions that you've got. You all know how to reach Jenny at NTMA and Christy at PMA as well. We'll stick on for about another 30 seconds and before we let you go about your day and your weekend. And a reminder, we still have that chat open. If you have not already, please do click on it and fill out that form in there that we're using that survey to apply to both associations, just interest of speed that was asked of us. And that way it all goes into one place and we can get anonymous and get it over to ILMA and be able to deal with EPA. Seeing no questions come in, thank you all for your time today. We will have our usual at the last Friday in July. I believe that ends up being again July 26th. July 24th will be misspoke. July 31st will be, yes, it is the last Friday, July 31st at noon Eastern. We will have our next webinar. Thank you all and enjoy the rest of the day.